Hello, class. Hope you're doing well. It's Professor Bile. I welcome you back from an extended spring break, and I reiterate what I've said in some emails. Let me know if I can help with anything as we go through this adjustment to an online format. If you have problem accessing things, if you have constraints of various sorts, let me know. Western has some resources. We'll try to figure out how to help you out. Now, today we're talking about breach of a duty. We're within the torts realm, and as I mentioned before, negligence is the most common type of tort claim that you see. There's a class of torts called intentional torts where people try to do something to hurt someone else. That happens if you punch someone, assault and battery. Those are criminal potentially, but they're also a tort that someone could sue for. But here we're talking about negligence and whether someone accidentally caused a harm to someone else. And that's, again, the vast majority of things with traffic accidents, with medical malpractice, etc. Now, we talked about harm. Plaintiff has to have actually been injured to have a tort claim. And we talked about how the goal of the law is to make that plaintiff whole again. Often we're talking about physical injuries and the law can't bring them back to the health level that they were at before. So we use money and we try to figure out the amount of money that it will take to make a plaintiff whole again, to bring them back from their injury. The other thing we've talked about is causation. We talked about how a plaintiff has to show that their injury was caused by the defendant. And there's two prongs to causation. There's the cause in fact, that the defendant's action has to be somewhere in the causal chain. If not for this happening, but for their defendant's activity, the injury wouldn't have occurred. We talked about how that includes a lot of things. If you hadn't been born, this injury couldn't have occurred because you wouldn't be here. But obviously that's not the sort of but-for thing we're going to look at. And so the other prong of causation is proximate cause. This has to be the sort of injury that is reasonably foreseeable for the person, the defendant, who engaged in these actions. And so we read the Palsgraf case where the woman standing on the train platform was injured by scales that fell down when someone kind of fell over and pushed them, when fireworks went off because railroad employees were pushing and pulling a guy to get on a moving train, and that guy dropped a package that happened to contain fireworks. And the court said that was not the sort of injury that is reasonably foreseeable for the railroad company. For them to be helping a passenger get on a moving train, it may be dangerous, and you may foresee injuries from that sort of thing. But not injuries happening on the other side of the platform because fireworks went off and there was some panic and things that ensued. So sometimes all we need to show is that there was an injury caused by the defendant's actions. When that's true, we call it strict liability regime. So it doesn't matter if the defendant was negligent or not, if we're talking about strict liability. If they had an action that caused injuries, they are legally responsible to make the plaintiff whole. So we see that with some things like wild animals. Sometimes celebrities keep a tiger as a pet. If a tiger causes injuries, it doesn't matter how careful you were at training your tiger or keeping your tiger in a certain area. If the tiger causes injuries, you are responsible for the damage that it causes. That's generally true of wild animals kept as pets. It's also something like blasting. We call an inherently dangerous activity. So in Nashville, there's a lot of construction going on. We're sitting on top of limestone, so they have to blast that limestone to be able to get down deep enough in the ground for a good foundation. When they're blasting, if that causes damage, they are responsible to compensate for it. It doesn't matter how careful they were when they were blasting. They still have to pay for it. Obviously, that's going to affect how careful they are because they know going in that they are going to be responsible for any harms that are caused. And we'll talk more about that element how we expect behavior to change because of different legal rules. But today what we're turning to is breach of a duty. And so the concept of a duty is that you owe to a class of people a duty to act in a certain way with a certain level of care. So if you're a driver, you owe a duty to all the other drivers on the road. You owe a duty to the passengers in your car, to pedestrians walking along the road. You owe a duty to all of those people to drive in a reasonable manner. So that's all that duty means, is it means that you've got this kind of reciprocal relationship to act in a reasonable way. And so we see that all the time. Employers have duties to their employees and vice versa. If we're thinking about consumers using products, the company that made the product has duties to the consumer. The consumer may have some duties to the company that made the products to use it in certain ways. When you have a duty, the question becomes whether you breach that duty with your activity. And so that's the fourth element of the negligence claim, is breach. So this is a question of fact, so it's usually decided by a jury. And they basically say, this is what we think of, at least what I think of in a colloquial term when I think about negligence. Was someone negligent? Well, did they fail to act in a reasonable way? So that's the question of breach. Did they breach their duty? The duty is you owe a level of care to people around you. Did you fail to live up to that? That's the question of breach. And so there's a famous case that I would have you read, but it's actually rather boring. So we're skipping it for reading, but I'll talk about it a little bit. It's called U.S. v. Carroll Towing. And it was decided, it's from 1947. It's about barges on the Hudson River on the side of Manhattan in New York. And a barge breaks free and it causes a whole bunch of damage. There's a famous judge named Learned Hand who decided this case, and he said, well, to figure out if there was breach, we need to look at what it would cost to take a precaution sort of activity. How likely is it that we're going to cause harm, if there is harm, and if there is harm, how big will that be? And we're going to compare basically what it costs to use precaution, and we're going to weigh that against the benefits of the precaution, namely decreasing how likely there is to be harm and how big that harm will be if it happens. And so that's a famous Learned Hand formula. We often call it BPL. B is burden of precaution, P is probability of loss, and L is loss. This was a big deal in the legal world because it kind of set out in words and even in math formula how to think about breaching a duty. And economists generally applaud the Learned Hand formula. The one big change that we see made is it's unclear the way Judge Hand talks about it, but economists definitely want to see this in marginal terms, not in absolute levels. So you don't want to look at the cost of taking precaution versus doing nothing, and the probability of harm versus no probability at all. What you want to do is look at things on the margin. What would it cost to take an extra little bit of care? How does that change the probability of loss or the level of loss or both? And so thinking in marginal terms, comparing what an extra bit of care and how that changes the likelihood of harming other people, whether that's slowing down your speed by 1 mile per hour. How does that change how likely you are to lose control and hurt someone else? How is that going to change how big those injuries are if you do lose control and hurt someone else? So that's the Learned Hand formula adjusted. So we'll talk about that as B versus P times L. And we'll see that worked into some problems going forward. So that's the big part of breach of a duty. I will see you guys soon. Thanks.